Hello, I'm Lauren Burns with SJF Law Group in Plantation, Florida. Today we will walk through what happens when someone dies without a will and how probate works in Florida from start to finish. Money stirs emotions. Some families handle things with grace. Others face conflict, silence, or worse. Our goal is a clear path that lowers stress, protects interests, and moves the estate forward. Think of probate like closing a small business. We identify who owns what, who gets paid, who inherits, then we close the books in the right order. Step 1, the first week. Secure the home, change locks if needed, protect vehicles, keep insurance and mortgage payments current. Order multiple certified death certificates. 10 is a safe number. Gather basics: IDs, deeds, titles, bank and investment statements, tax returns, and any beneficiary forms for life insurance or retirement accounts. Do not pay debts from your own pocket. Wait for court authority and an estate account. Step 2. Separate probate assets from non-probate assets. Non-probate assets pass by beneficiary designation or joint ownership. Life insurance, IRAs, 401ks, POD, TOD accounts, and joint accounts with rights of survivorship. Those pay directly to the named person or the other co-owner. Probate assets include things titled in the person's name alone: a house, a car, bank accounts without a named beneficiary, and personal property. Florida homestead is unique. It is protected from most creditors. We file a petition to determine its status as homestead, then it passes under Florida law. Step 3. Pick the right probate path. Summary administration works if probate assets are $75,000 or less, excluding exempt homestead and exempt personal property, or the death was over 2 years ago. Faster, fewer steps, no personal representative in most cases. Formal administration fits larger or complex estates, creditor issues, unknown heirs, or real estate sales. Step 4. Who serves as the fiduciary? Florida uses the term personal representative, not executor. Priority in intestacy, when there's no will. First, the surviving spouse. Next, a person chosen by a majority of the heirs. Next, the nearest heir. Qualifications matter. A PR must be an adult, have no felony conviction, and be mentally and physically able to serve. Non-residents must be related by blood, adoption, or marriage. An out-of-state friend has no eligibility. Having co-PRs often slows things. One qualified PR with transparency often works best. Step 5. File the case. Venue sits in the county of Florida domicile. We file a petition for administration, listing all heirs with addresses, stating there is no will, and asking for appointment of the PR. We file the PR's oath and a designation and acceptance of resident agent in Florida. Some courts require a restricted depository for estate funds. A bond might be required. The court issues letters of administration. That paper gives the personal representative authority to act. Step 6. Set up the estate. Get an EIN from the IRS. Open an estate bank account. Deposit estate funds only. No commingling. Serve the notice of administration on interested persons. Publish the notice to creditors in a local paper and serve known creditors directly. Unknown creditors get 3 months from first publication. Known creditors get the later of 30 days from service, or the 3-month window. After 2 years from death, most claims are forever barred. Do not pay claims early. We sort, object to invalid claims, and pay in the correct order. Step 7. The order for paying claims. Florida Statute 733-707. Class 1. Costs of administration, PR, and attorney fees. Class 2. Funeral expenses up to $6,000. Class 3. Debts and taxes with federal preference. Class 4. Last 60 days of final illness expenses. Class 5. Family allowance. Class 6. Back child support. Class 7. Business obligations from post-death continuation. Class 8. All other claims. Step 8. Prove heirs and shares under Florida intestacy. Chapter 732. If there is a spouse and no descendants, the spouse inherits everything. If there is a spouse and descendants, and all descendants belong to both, and the spouse has no other descendants, the spouse inherits everything. If either has descendants from outside the marriage, the spouse receives 50%. The other 50% goes to the decedent's descendants per stirpes. No spouse, then to descendants. No descendants, then to parents, then to siblings and their descendants. If none, Florida goes further out on the family tree. If no family, the estate escedes to the state. Adopted children inherit the same as biological children. Half-blood siblings take half shares when mixed with whole-blood siblings. Non-marital children inherit from the father if paternity is established. DNA, Court orders or clear acknowledgement help. Step 9. Special Florida issues. Homestead. If a spouse or minor child survived, no devise to others. The spouse receives a life estate with remainder to descendants, or the spouse may elect an undivided 1/2 interest instead. Election deadline is 6 months from death. Exempt property, certain personal property, and 2 motor vehicles qualify. Family allowance supports a surviving spouse or lineal heirs during administration. Multiple marriages and blended families bring split shares by statute. Clear math avoids fights. Unknown heirs require heir search and a court determination of heirs before distributions. Out-of-state heirs can sign documents remotely. Florida allows remote online notarization with approved providers. Large banks might ask for medallion signature guarantees for securities. Property in another state may need ancillary probate in that state. Likewise, a non-resident with Florida real property needs Florida probate. Step 10. Reporting and closing. File the estate inventory within 60 days of letters of administration. Keep detailed records, save receipts, track time and decisions. Communicate with heirs, regular updates, lower suspicion, and lawsuits. After the creditor period and asset collection, file an accounting or waivers, propose distributions, secure receipts, then seek discharge of the PR. Timeframes. Summary cases often wrap up in 1 to 3 months. Formal cases often run 6 to 12 months. Disputes, tax issues, real estate, or missing heirs can extend timelines. Practical tips from the trenches. Order plenty of death certificates. Now, do not remove items from the home before inventory and photos. Beware of fake bills or surprise storage or towing invoices. Require proof. Object to bad claims on time. Pay nothing from personal funds. If you do, document and seek court-approved reimbursement. Remember, Florida law doesn't require a reading of the will. In intestacy, there is no will to read. Heirs receive information through court filings and notices. Probate is a process. Steps in order, patience, and steady communication save relationships and dollars. If you want more information on this topic, reach out to one of our experienced probate attorneys today. Also, if you haven't already, make sure you're subscribed to our channel so you'll know whenever we have a new video.